Hello? Can you hear me?
Yes.
You had it?
Yes, yes.
Can you hear me? Can you hear me? You can't hear anything, no.
No, you can.
Can you hear?
You can hear from me now. Go, okay, go, step outside. No, let me step outside.
Yo, let me step out.
There's a next.
Yeah. Can you hear me? Can you hear me? Can you hear me? Ah. Can you hear me? You can't hear? That's it.
I can hear, but you can't hear.
Let me see. But it's not, I'm not here. Can you hear me?
Yeah, come here.
Can you hear?
Okay, you're hearing from the Zoom.
No, let me step outside.
Yo, let me step out.
There's a next.
Can you hear me?
Yes.
You can hear. You have it?
Yes, yes.
Yeah. Can you hear me? Can you hear me?
It's your own phone.
Can you hear
Okay,
me?
let me join the YouTube.
Can you hear me? You can't hear anything.
No, you can.
Can you hear? Can you hear me?
Is it YouTube you're hearing from?
Ah.
No, it's from Zoom.
No, let me step outside.
Yo, let me step out.
There's a next.
You can't hear?
I can hear, but you can't hear.
Let me see. Yeah, but it's not, I'm not here. Can you hear me? Can you hear me?
Okay, you're hearing from the
Can you hear me? Ah.
I can hear.
Can you hear me?
You can hear from yours.
Yes.
Let me admit the
Hello, everyone. Good morning.
Alan, good afternoon.
Good afternoon. Okay.
Okay, I'm sure we're waiting for once it's off, we can start.
Okay. 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 Good morning, everyone. Yeah, my name is Alan, and I want to welcome you to today's webinar. The title of our webinar today is Cybersecurity and Data Protection Laws, the Nigerian Experience. And before before we commence, we want to set down some ground. Please, if you're in a noisy environment, you might want to mute. Okay, if you're in a noisy environment, you might want to mute. And if you want to share something with us, kindly put up your hand. We would come to you. Okay. So with that, we'll commence in earnest. All right, so let's start in earnest. Please, we would like to call on the chairman of the NBA Port Harcourt branch. Please make welcome Mrs. Cordelia AK for her opening remarks and to address us before we commence. Thank you, ma'am. Please, you can have the mic.
Okay, sure. Good afternoon, my distinguished colleagues. It's my honor and privilege to welcome you to this webinar on the cybersecurity being organized by the NBA Port Harcourt branch. I hope you all can hear me.
Yes, we can hear you, madam. We can hear you.
Okay, that's great. My name is Cordelia AK, Chairman of Nigerian Bar Association Port Harcourt branch. Well, as you all know, we are in the era of improving our capacity, that's capacity development, and with the posture of the NBA president to do the best he can, or the association can, to improve capacity of So this webinar on cybersecurity is actually coming at a good time because most of us are online carrying our one activity or the other. And sometimes we assume that some of the things we're doing are just a matter of course and forgetting that they actually, they may be in breach, data protection laws and all. So I wouldn't say much. I know we have very strong persons here. We have our resource persons that will do justice to the topic on hand. So all I'll just say right now is sit tight and key into what is going to be presented today. And please stay to the end so that you can get your CPD points. So ladies and gentlemen, thank you for joining our webinar. And I wish everyone happy deliberations.
Thank you very much. Thank you very much, madam. Thank you. So with that, I'll just call up, I'll introduce the facilitators. Today, we will have 4 facilitators to speak about today's topic. And the first is Mr. James Derby. James needs no introduction as a distinguished thought leader in data protection in Europe and Africa. He graduated from the Lagos State University in 1990 with an LLB degree and was called to the Nigerian bar in 1991. He worked for a few law firms in Lagos before he set up his law practice in 1997. He relocated to the UK, specifically England, in 2001 and was admitted as a solicitor in England in Wales in 2004. He has practiced as a corporate solicitor and data protection and FOI compliance attorney. He worked as the data protection officer in over 5 different local authorities in England. He was the lead data protection solicitor for the Ministry of Justice, London, and he advised Her Majesty's Prisons and Probation Services and the Minister of Justice / Lord Chancellor on data protection matters. James was the Information Governance Solicitor at the British Broadcasting Commission, BBC, London, and he advised on data protection, FOI, and information governance. James has presented several papers, including one at the Cambridge University, England, another at the Africa Bar Association Conference, Nairobi, Kenya, another at the Nigerian Institute of Advanced Legal Studies, and he has taught several professionals in Nigeria, conducted capacity building sessions, including 300 mid and senior level staff members of the Central Bank of Nigeria, which he co-opted me sometime in 2021. I was assisting him then. And he also trained the Corporate Affairs Commission, Lagos Inland Revenue Service, several financial and multinational companies here in Nigeria. Please, James, you're welcome.
Thank you, Alan. Thank you very much for that kind words. Thank you so much.
Thank you very much. Thank you very much. We also have the second facilitator today, and she'll be speaking. Lesemi Wokoma. Lesemi heads the Corporate and Compliance Department of Principles Law Partnership. I can hear myself echo. Okay, so Lesemi Wokoma heads the Corporate and Compliance Department at the Principles Law Partnership. She obtained her master's degree in International Commerce and Maritime Law from the University of Swansea. She has a strong focus on corporate governance, regulatory compliance, risk management, and broad compliance among industries. Her forte is data protection, privacy, and cybersecurity, and she'll be sharing a whole lot of that with us today. Welcome, Lesemi. Please say hi to us. Is she there? Okay. Just a moment before I. Okay, all right. So when she comes, I'm sure that she will unmute and say hi to us. And I would go to the third facilitator that will be addressing us. Her name is Onyinyechi Nwachukwu. She is an ISO 27001 lead implementer and lead auditor with deep experience in cybersecurity governance, risk, and compliance. She currently serves as the lead data auditor for data protection compliance organization known as Cyrex Law. And she plays a vital role in driving data protection standards and regulatory compliance. She is the IT and cybersecurity person, and she will make us to feel that. By the way, she has almost 2 decades of experience and standing at the bar. She's a seasoned legal practitioner based in Abuja. Onyechi, please, if you're here, can you unmute, turn on your camera and say hi to everyone? Okay. Anyways, James is the first, so I'm sure that they will all join. Then the fourth, but by no means the least, is our regulator from NDPC, represented by Ibudolua Owa. So Ms. Owa is a legal practitioner with over a decade of experience. She worked at leading law firms in Nigeria, London, Hamburg, and she is also a dispute resolution and international arbitration expert. She obtained her master's degree from the University of Swansea, and she works with the Nigerian Data Protection Commission, and she'll be speaking with us on the perspectives of the regulator today. Thank you, everyone. Please, let's make welcome James, and let's start in earnest. James, I'm very eager to hear what you have to say to us. Are you there?
Hi, everyone. Hi, Alan. Nice to see your lovely smile again.
Thank you.
Thanks, everyone. Thanks for joining this webinar. I've got a couple of things to say. Data protection, as Alan had said, I've been a data protection solicitor in England. So my presentation would probably be a hybrid of what obtains in UK and a bit of what obtains in Nigeria. I know most of the participants here are in Nigeria, but we live in a global world, and we will try and make the best use of everything we have regarding our expertise and knowledge. A big thank you to MBA Port Harcourt for inviting me to join this webinar. It's always very good to share experience with my people in Nigeria. So I look forward to talking to you about some basic stuff about data protection. It is very interesting when the chairman of the MBA Port Harcourt made a presentation, and she alluded to the fact that data protection is the new oil. I know Port Harcourt is the regiment where we talk about our oil in Nigeria, but data protection is now the new oil. And coming into the world of AI, AI and data protection run pari passu. So it's very interesting that you can bring this topic out for us because of a lot of things happening in the world now. So I'm more than happy to share my skills, my experience in a very practical way at this webinar, so we can engage together, and this capacity building opportunity will be well used for all of us, and particularly for those in practicing law in Nigeria. Thank you, Alan.
Thank you very much, James. I can see that you're wearing your nice suits because it's summer. Anyways, I want to find out, quick one, what is personal data?
Okay, so personal data is defined in the UK GDPR under Article 4 of the UK GDPR. In pari material, under Section 65 of the Nigerian Data Protection Act of 2023, the personal data concept has been defined. And I'm not going to be talking legalistic or technical stuff. I'm going to be very practical in this short 10 minutes, 15 minutes I've got with you guys. Personal data is any set of data that can lead to an individual being identified. It could be an identifier. It could be things like names, email addresses, photographs. It could be online identifier. It could be things like location data. So personal data is all those things that can lead to individuals being identified. And really, when we talk personal data, we talk about living individuals. In as much as the legislation, both in the UK and in Nigeria, does not qualify it as being living individual, in practice, we always relate personal data to living individual. So, for example, we get cases whereby people will ask, look, I want information under the subject access request rights about the information about a family member who has died under the UK GDPR or Nigerian Data Protection Act. The moment you get such information or such queries, the first thing we want to do is that, look, personal data is only applicable to living individuals. So rule of thumb, the first thing you want to confirm is this information they are seeking or you are processing, we're going to talk about processing later, does it relate to a living individual? If it is a living individual, then you talk about personal data. Another thing that I really want to put out to us is about that principle called identifier. Sometimes we underestimate what identifier means. I would give you an example. I went to my local hospital on Monday. I had a blood test to do on Monday, and I took my blood test form to the reception. I saw the receptionist, and she said, "What is my appointment time?" I said 7:40 a.m. He said, "Oh, it's 7:30. Go to that small box there and register." I went to the small box there. There's a small box by the receptionist, and on the small box, it just says enter date of birth. And I put in my date of birth, 09/07/2001. And immediately, yes, I was born in 2001. And immediately, something came up and said registration completed. And on the screen up, my name came up saying, what time is my appointment? You can see what happened there. I only imputed my date of birth. Because that date of birth becomes my personal data, they were able to process it through the IT systems in that equipment, and they were able to aggregate all my date of birth on that system, and I was able to do my blood test. So when we talk about personal data, it is everything that will relate to an individual, a living individual being identified. I give you one second example about a query I did on Tuesday. A client came to me and said, look, Mr. Debbie, there's been a breach of personal data. Somebody has sent out the names, first names of about 20 individuals to a wrong recipient. And when I processed that data breach form, the names were only the first name. So the first name, would it lead to an individual will identified? For example, let me say Alan has breached a data protection processing activity. And I said, look, there is this particular person called Alan. He went to the Nigerian law school in 2002. Would that lead to Alan Amadi being identified? No, it's not Alan Amadi because it's just Alan. So when we talk personal data, we need to really understand the definition of personal data, that it would be something that would lead to an individual being identified. So that for me is the summary of what personal data is.
Okay, wow, thank you. All right, so another question is, what is processing? What is processing of personal data?
Processing is a technical term we use in the data protection space. It's anything that will be leading to whatever identity process activity.
Hello, James. Can you hear me?
Can you hear me? Alan, can you hear me? Okay. Processing is a technical term.
Yes, please.
Okay, cool. Processing is a technical term in data protection space. It means any operation or set of operations which is performed on personal data. And processing has actually been defined in Section 65 of the Nigerian Data Protection Act of 2023. Similarly, the term processing was defined in Article 4 of the UK GDPR. These are similar legislations across both jurisdictions, so I'll be referring to both legislations in the course of my presentation. And processing is actually anything that you do on what we call personal data. Take, for example, you are collecting personal data. Somebody comes to your bank, you work in a bank, and they want to open a form, a current account form, account. You collect their personal data, their names, their BVN, their NIN. These are examples of personal data. The moment you are collecting their personal data, you are processing their personal data. So processing does not stop from being collection of personal data. It includes things like retention, erasure, disclosure. There's so many technical things that you do that constitute processing of personal data. It's actually any set of activities that you do that operates on personal data. So whenever you do anything regarding personal data, that operation becomes a processing activity. And it is very important to know whether you are processing personal data or not, because in the data protection space, we have clients come to us and say, look, I want to do this technology. How can I do this technology? What are my legal obligations? The first thing is you want to find out, is their personal data? Are they processing personal data? If they are processing personal data, then you get into the world of the data protection impact assessment, which I'm sure some of the panelists are going to talk about. Data protection impact assessment, DPRA acronym, is a process whereby you assess the risk of processing of personal data. So whenever you have any activity on personal data, that activity that you're engaging in constitutes processing of personal data.
Wow, thank you. Thank you very much, Mr. Derby. Sorry, you sent us your slides, but you prefer a dialogue just so that you can drive home the key points, which is
I think my
question.
Sorry, Ale, I think my style is, whilst I like to do slides, my preference is always to speak from the art, give practical examples so that people can be engaged, people can be interactive. So please pardon me, I've got slides. I'm sure Ale will share the slides with you, but I really want to speak from the art to you guys because I want to impact some knowledge to you guys.
Thank you. Thank you very much. So next question, James, I'm very eager. What, in what instances would processing of personal data be lawful? You just talked about and defined what processing activities are. So in what instances would processing be lawful and without any liabilities whatsoever?
Alan, you and I have done this over the years when we talk about lawful processing of personal data. And I would start from where it starts from. Section 24 of the Nigerian Data Protection Act provides for 6 data protection principles. Likewise, under Article 5 of the UK GDPR, the same data protection principles are provided for. The first data protection principle states that personal data must be processed fairly, lawfully, and in a very transparent manner. And you can find out that in that set of first data protection principle is the word lawful processing of personal data. And that gave rise to what we now call as lawful basis of processing personal data, which was explicitly stated in Section 25 of the Nigerian Data Protection Act of 2025, which is in pari material with Article 6 of the UK GDPR. So, in summary, there are 6 lawful bases for processing personal data. And I would go and speak in summary about the 6 lawful bases. Alan, I can see you smiling because you know these are the things we teach our clients whenever we teach on data protection and legislation. The first lawful basis for processing of personal data is consent. There must be informed consent. The concept of consent is a very big concept under the data protection legislation. There's something called informed consent. And when we talk about consent, we are talking about consent which the individual must have put in some form of assurances that, yes, they have capacity, they know what they are consenting to and all that. So consent is a very big lawful basis for processing personal data. For example, you go to a bank and you want to do some stuff in your account. The bank will ask you, do you have some consent to do this, or do you have your consent to do this? So sometimes the consent principle is very, very engaging. Whilst consent is very important, I would like to plug something in, because when we talk about consent, we need to look about whether an employer, because this came up to me recently in an advice I gave to one of my clients who is an organization and wants to use the images of their employees on their website, and whether what is the lawful basis for them to process that personal data. So for an employer to have consent from an employee is a very tough task because of the relationship of employer and employee. And sometimes because of the overpowering relationship between employer and employee, there's a school of thought that says that that consent may not be very informed. So we need to be careful when we are talking about consent between employer and employee. Likewise, consent between a child and an adult. We need to be careful about the consent between a child and an adult. I'm sure in Nigeria, the Child's Rights Act says something about what is the lawful age of a child. But in the UK, we have something called the Gillick consent, which talks about when a young person can have consent or capacity to consent on it. But I will leave consent as a lawful basis because we have a couple of things to do. The next lawful basis that we use in data protection processing activity is contract. When you have a contract with an individual, then you have the legal basis to process their personal data. So if, for example, you are engaging an insurance company to do your life insurance, you provide them with your personal data and all that. Because of the insurance contract with that insurance company, with the data controller, they have a legal right to process your insurance contract with them. So contract is another lawful basis under the data protection regulation. The next lawful basis is compliance with a lawful obligation. In the example I have given in my slides, which you've seen, if there is a lawful obligation on the data controller to process your personal data, then there is a lawful basis. For example, some financial institutions have lawful basis to process information because of the requirements under the Fraud Act or something similar to that in Nigeria. Financial institutions have some lawful basis to do that. So it's a compliance with obligation. The next lawful basis is vital interest. It's one of those lawful basis that people don't usually use because it's a matter of life and death situation whereby you use vital interest. For example, some of us who are young enough to be alive when there was this footballer, Okparachi, I can't remember very well, died in Nigeria, was playing football. Assuming he didn't die at that stage and they wanted to get information about him from his medical people, they would use the lawful basis of vital interest to process his personal data. It's a life and death situation whereby you can use the lawful basis of vital interest. In the UK recently, about some years ago, we also had a footballer who had a cardiac arrest whilst playing football on the pitch. I am sure the football team would have contacted his local hospital and have asked for some information about the gentleman before he was even moved to the hospital for him to be processed whilst on the pitch. The lawful basis they will have used would be vital interest because it's a life and death situation whereby they needed to process his personal data. The third or the fifth lawful basis which I want to talk about is performance of a task in the public interest. This is very applicable to public organizations, people who carry out public service. Once you are performing a task in the public service, you can rely easily on performance of the task in public interest. The last but not the least lawful basis is what we call legitimate interest. It's the most flexible lawful basis, but it's the most difficult to apply because you have to balance the right of the data subject against the right of the data controller. And whenever you are trying to process information using the lawful basis, you have to do something we call privacy impact assessment, PIA, when you want to process information using the lawful basis of legitimate interest. So in summary, there are 6 lawful bases under Section 25 or Article 6 of the UK GDPR, whereby you can process personal data lawfully. However, and I must caveat this, there are exemptions under the Data Protection Act in the UK and in Nigeria where you can also process lawfully information where any of those exemptions are engaged. For example, if you are processing data for the apprehension, prevention of crime, the police can usually use that and rely on that exemption as a lawful basis for processing personal data. So the concept of lawful basis is codified in our laws in Nigeria, Section 25 of the Nigerian Data Protection Act 2023, likewise in the UK, Article 6 of the UK GDPR. Thank you, Alan.
Thank you. Thank you very much, James. I think we're running out of time. I know that people will have lots of questions to ask. So, quick one. What can I do, or what can we do if our personal data is unlawfully processed? You see loan companies calling people, sending messages and all of that. What can one do if his personal data is unlawfully processed?
Alan, I'm sorry I ran out of time. I apologize profusely on that. I'll make it very short. Look, if your personal data has been breached, the first thing you need to know is your personal data. The next thing you need to know, there is no lawful basis for processing the data. Once those two things are engaged, the next thing you want to do, practical thing, is to contact the data controller, make a complaint to the data controller, and see whether they would rectify the issue. If the issue is not rectified, the best option is to go to the commission, the Nigerian Data Protection Commission. They have powers under the legislation to investigate complaints. If you go to the commission, some of the things that they can do is, following their investigation, they can award you compensation. Unlike in the UK, if you have a complaint and you go to the Information Commissioner's office, the Information Commissioner will investigate, but the Information Commissioner does not have powers to offer you a data subject compensation. What the Information Commissioner can only do is to award a fine against the data controller. Under Article 82 of the UK GDPR, you have a right to compensation, and that right, you have to seek it in the courts. Likewise, if you are not happy with the outcome of the commissioner's investigation, you have a right to go to the court of competent jurisdiction, either the Federal High Court or the State High Court, and you can try to enforce your rights at the courts. So I would make it very brief that you have rights under the Nigerian Data Protection Act for any breach of personal data.
Thank you very much. One last question before we leave us. But you still be around because there'll be lots of questions. There'll be question and answer time, and I'm sure that people will have some questions for you. So, is there any requirement to keep an inventory of processing activities so that it can be checked whether it's lawful or not? Is there any obligation on persons that process personal data to keep an inventory? How, if there is, then just elucidate on it.
Look, under the Nigerian Data Protection Act 2023, there is no express provision in the legislation for records of processing activity. However, there is a guidance which has been issued by the Commission. And in that guidance, I think a part of that guidance expects a data controller to have something called a record of processing activity. That recording of processing activity would involve a lot of processing activities that the organization is carrying out. In practice, this is the practical thing. Most organizations would have what we call information asset register. This is the snapshot of what should be in the record of processing activity. As long as you can provide that your information asset register to the supervisory authority, I think you are good to go. However, the rule of thumb is that, look, records of processing activity is always difficult to get right because of the level of detail that is involved in that record of processing activity. So what we advise clients to do is to have something called information asset register, which is going to provide a snapshot of your records of processing activity.
Thank you very much, James Derby. We'll call on you again. So in sum, you have defined personal data. You've also talked about the lawful basis, giving examples. There are 6 of them. But you started from the principles of personal data, and one of them was lawfulness. Then also you've given us the difference between IAR and
I think Alan has frozen up.
records of personal activity in the unlikely event of a person experience with us. Just stay around whilst we thank you very much. Right. Okay. Hello. Oh. Okay. Hello, James. Can you hear me? Can everybody hear me?
Yes,
Yes.
you froze up initially, but it's better now.
Oh, okay. Okay, so James, thank you very much. I was just doing a quick recap of your presentation and then appealing to you to please just stay around whilst we approach the question and answer session, so that I'm sure that we have our inbox here. There are some questions, and we would like you to address some of them that address to your presentation.
I'm happy
Thank you
to
very much.
take questions. Thank you so much. Thanks for inviting me, Alan.
Thank you. All right. So please, ladies and gentlemen, make welcome Lesemi Wokoma. She is our next facilitator on this session. Like I said, she heads the corporate commercial department at Principal's Law Office. She's here. Lesemi, please, can you turn on your camera or mute and then say hi to everyone?
Good afternoon, everyone.
Yeah, can you hear me? Or is my speed? Yeah, afternoon.
Trying to join.
Welcome. Great.
Yes, Alan, can you hear me?
Thank you very much. Such a bright face. Loud and clear. Great. Okay, so yes, so you were talking to us on data subject rights and everything around it. Would you like to share a screen, or would you like a dialogue format so that I can
Unless I will create a dialogue format. My slides could be sent later.
Great. Thank you. Okay, so regarding your presentation, data subject rights, what are data subject rights? Are they similar to the rights that we have under the Constitution?
Okay, data subject rights are not entirely and explicitly provided for under the Constitution. Not all data subject rights are explicitly provided for under the Constitution. By virtue of Section 37 of the Constitution, the Constitution provides for the privacy, for the guarantee of privacy for individuals, their homes, their correspondence, and all that. So yeah, it could be said that the Constitution gives you the right to privacy. However, Nigerian Data Protection Act, the statutes, itemizes, provides expressly for data subject rights, and not all data subject rights provided for in the Nigerian Data Protection Act can come under data privacy, like the right to information, the right to erasure, the right to be forgotten. Such rights cannot be enforced under the fundamental rights as the rights provided for under the Constitution. So what are data subject rights? Can you hear me?
Yes, I can hear you. Please go ahead. Yeah. Hello, listen, are you with us? Okay. Can everybody hear me? Let me just make sure that it's not my network.
Yes, we can hear you, Alan. We can hear you.
Oh, great. I'm sure she would be speaking to us shortly. Sure about that. I keep you just 1 minute thereabouts. Just a moment, please. Okay. Yes, welcome back.
I got logged out.
Okay, welcome back. Please turn on your cameras and continue from where you left off. Thank you. Hello. So while she's trying to get up, is she there? Okay, so while she's trying to get up, maybe I'll have to share my screen. I'm showing you my network because I'm struggling to hear. That's not my network.
I think the problem is from our side.
Okay, great. So let me just share her slide. She sent her slide before now. I'm sure that we'll just be going after it slide by slide, and I'll be putting in a few words. Then once she joins, we are going to quickly stop the presentation, and she will take up our presentation. So her presentation is on data subject rights, and she defined it and went ahead to mention the data subject rights. The first is rights of access, subject access request, section 34, sub 1, paragraphs A to B of the Nigeria Data Protection Act. And then she goes on to explain that data subjects have the right to know if any personal data is held about them. They have that right to ask for it. And if it is confirmed that personal data is held about them, they have the right to know, okay, what personal data, who has it been shared with, what third-party countries are these individuals in, for how long will this personal data be held, okay, and has it ever been subjected to automated decision-making. They have the right to ask for these things after it's confirmed that personal data of them is being held at all. Okay, and then she's also saying that although the Nigeria Data Protection Act does not explain what unreasonable delay is, but it is advised that a subject access request should be treated within 1 month of receipt, and that the NDPA says that data subject rights must be without constraint or unreasonable delay, and that where a subject access request is repetitive, okay, or fishing in nature,
Hello, Alan.
just indeterminate. Yes. Okay. Welcome back. Please continue. I was just trying to hold the fort while you join back. So I'll stop sharing my screen now, and we take up from where
Thank
we
you.
stopped. Thank you. Yes, please.
Okay. So what are data subject rights? Data subjects. Okay, what are data subject rights? They are legal rights created by the Nigerian Data Protection Act. Just summarily puts you in charge of your data, how your data is being collected, how your data is being processed, who has access to these data, how long your data is going to be stored. It literally puts the data subject in charge of their information, in charge of their rights. So what are these rights? These rights are provided for under Part 6 of the Nigerian Data Protection Act, provided for under Part 6 of the Nigerian Data Protection Act 2023. And these rights include the right to be informed. A data subject has the right to be informed. What does this mean? It means that as a data subject, at the point of processing your data, at the point of giving out your data to data controllers, you have the right to know what exactly they are getting from you, what information they have of you, how are they processing this information, how long is it going to be stored? Are there third parties that would have access to this information as an individual giving your details out? You have the right to know that. You have the right to be informed generally about your data. What policies do they have? So what most organizations do is that they have a privacy policy where they itemize all these details, they itemize the information they get from you, how it's going to be processed, how it's going to be stored, the third parties that are likely going to come in contact with these data they have of you. And unfortunately, a lot of us don't even take time to go through the privacy notices of most of these organizations, of most companies. We are always in a hurry to access whatever information we want to get from these organizations, that we don't even know that we have the right to request that they let us know the information they have of us. Another right a data subject has is the right of access, the right to access. Upon processing of your data, you have the right to know what these organizations, what the data controller has of you. You have the right to know your data. You have the right to access what document they have. I'll just give us an example. There was a time I went to a hospital in Port Harcourt here, and I was supposed to do a test, a medical test. I had done my lab test, I had done the test, and I was to be giving my results. The hospital runs a policy where informations are transmitted between the medical doctors and the lab attendants in the hospital. However, it was my information. This was my test result. And when I went to the lab, they said, oh, your result has been sent to the doctor. I said, oh, that's fine. I need to also see my result. I need to have an idea of my result. And they're like, oh, that's not our policy. I had to make her understand that this is my document. This is my information. It's my right. I have the right to retain this information. I have the right to see what is on that result. And there were a lot of back and forth, but at the end, I was giving my test results. So as an individual, you have the right. You have the right to request, what is it that you have of me? Can I access it? Can I be able to see such rights? Another right an individual has, a data subject has, is the right to object. The right to object to the processing of their data. Can you hear me, Alan? Can anybody hear me?
Yes. We can hear you. Please, are using the slides. If you notice, I've already displayed it. I think let's use the slides. Thank you.
Okay, so another right an individual has is the right to object. What does this right mean? It just means that you have the right to say no. You have the right to say no to how your information is being processed. You have the right to, even if you have given a consent earlier, you have the right to say no, I no longer want to go on with this consent. You have the right to limit whatever they have of you and how it's being processed. What this just does is that the Data Protection Act puts this right back into the hands of data subjects. This is your right. This is your weapon. You need to use your right as a data subject to protect your digital rights. So what does it mean? You just have the right to say no. Let me give an example. A young person probably goes to the gym. Yes, let me use that example. Goes to the gym. He's already registered in the gym. And on one of the days he goes to the gym, prior to this day, they usually enter the gym or access the gym with the gym membership card. And on this day, they are saying, oh no, you need to put in your biometric information. And he asked them, what do you need my biometric information for? Even if I have also given my information prior to this time, my name, my contact details, because I'm registered in the gym, I'm a financial paying member of the gym. I am not comfortable with giving my biometric. At this point, as a data subject, you can object. What third party is going to get access to biometric information? So as a data subject, you need to utilize your right to objection. You have a right to object to how your data is being processed. A data subject also has the right to erasure, to ratification. Yeah, there are information that would have been gotten from you as a data subject prior that were correct, and sometime later it becomes misleading. As a data subject, you have the right to rectification. You have the right to contact the data controllers to correct whatever information they have of you. Yes, the Data Protection Act provides you or gives you that right to rectification. And in the event that such cannot be done, yes, they have the right to correct totally, to delete if they cannot rectify. As a data subject, you must be bold about your rights. You must let them know this information you have of me Maybe you got it when this information was correct. Right now, this is not the correct information. This information is misleading. As a data subject, you also have that right. A data subject also has the right to withdraw consent. The earlier speaker also made mention of that. You have the right, even if you have given a consent earlier, you have the right to withdraw your consent. If by the way they are processing your data, you are no longer comfortable with it, or the legal basis for which that data that was gotten has been fully processed, as a data subject, you have the right to withdraw your consent. A data subject also has the right to erasure or to be forgotten if an information has been gotten from you, the data subject. If an information has been gotten from you, the data subject, as a data subject, you have the right. The Nigerian Data Protection Act empowers you to enforce your right of erasure. You have the right to inform the data controllers to take whatever information they have of you. However, are all these rights absolute? Are these rights absolute? These rights are not entirely absolute. There are exceptions.
Hello, are you still there? Hello, are you still there? I think you stopped for a while. Can everybody hear me?
Yes, we can, Alan.
Okay. Okay, I'm sure that she'll join up to complete her session. I think we have just
Hello,
a
Alan.
few
Can you hear
minutes.
me? No, I just forget to
Yes,
the
yes,
network
yes,
is
yes,
really
yes,
bad.
please.
Can you hear me, Alan?
Please. Yes, yes, I can hear you. Please proceed. You're
Hello.
talking about exceptions to rights. Yes, please go ahead.
Okay, so yeah, there are exceptions to these rights. If the processing of the personal data is done in a lawful capacity, there are several exceptions to these rights provided for under Section 3 of the Nigerian Data Protection Act, which include for security measures, law enforcement, prevention, or control of national public health. It also includes publication for public interest, research purposes, journalism, and all that. Those are the exceptions. In those capacities, a data subject might not be able to enforce these rights completely, and also the right to be forgotten as well. Most financial organizations, most financial institutions, they are bound by some laws like the anti-money laundering laws, which expect details of data subjects which have been gotten by financial institutions to be kept with the financial institutions for a period of time. So a data subject, even if you want to erase your information or to be forgotten, there are exceptions, and these fall under some of those exceptions to the right of a data subject. Hello, Alan.
Yes, yes, yes. I can hear you. You stopped.
Okay, I'm done with the data subject rights.
Okay, okay, okay. Please can you tell us the exceptions, because I believe that there are instances where okay. I think you've touched on exceptions a bit. Can you throw more light? Now, every right places an obligation on somebody else. Now, if this right is breached, what can the data subject do if their rights are breached?
Okay, if a data subject discovers, the first thing is to know your right as a data subject. You need to know your rights before you know if it's being breached. So once a data subject discovers or comes to the knowledge that their right is being breached, the data subject it's expected to get in touch with the data controller or the data processor from where such breach came about, inform the data controller, the data processor of the nature of the breach. Yes, and the data subject also has the right under the Nigerian Data Protection Act to file a formal complaint with the Nigerian Data Protection Commission, Nigerian Data Protection NDPC Commission, file a complaint with the NDPC, file a complaint with them, attaching the details of your correspondence with the data controller. The data subject also has the right to seek legal redress in court.
Thank you very much, Lesemi, for your time. I think we run out of time and would like to call the first speaker. But in summary of what you have said to us today, you have defined data subject rights and you have distinguished it from constitutional rights. And then also you have outlined the data subject rights, such as right to rectification, right to be forgotten, right to access, right to be informed, and right to objection, several rights. And you have also emphasized that those rights are not absolute. There are instances where the rights do not apply, such as Section 3 sub 2, which is where the Nigeria Data Protection Act has exempted the application of the NDPA. It will apply. Investigation of crime, enforcement, all those things are not subject to. They have also told us what we should do when there is a breach of personal data right, which is we can lay a complaint at the NDPC website. We can consider civil action. Can also consider approaching to rectify it. Thank you very, very much. And I also urge you to please stay around. We'll call on you not too long from now. Already we're having questions in our chats regarding your presentation. So just stay around for another maybe 35 minutes, 40 minutes. We'll call on you to come and answer some questions. Thank you very much. And thank you. With that, we'd like to welcome the third speaker today, Onyinye Chinwachukwu. She's an ISO 27001 certified auditor, and she's our cybersecurity expert. I mean, her profile is so rich, but basically you'll be hearing everything around protection, cybersecurity, technical things, jargons, and please welcome with me, Onyinye. Onyinye, if you're here, please open your camera and say hi to everyone. And take it up from here. Hello. Yeah, I think she was here a while ago. Yes, I can hear you, Onyinye. Is that you?
Can you hear me?
Yes, we can hear you. Please do speaking, because I can't see any person's camera.
My camera is on. I don't know what's going on. Good afternoon, Alan.
Afternoon. I'm delighted seeing you, even though I can't see you with my eyes, maybe with my inner eyes. But yes, the floor is up to you. We'll share your slide and then we'll let you do your thing, okay?
Okay, I'm wondering why I can't see.
Really, I should turn on my camera. Okay, great. So the screen is coming up in a bit. Okay, you're sharing from your end. That's great. Okay, no, you're not sharing.
I'm going to share from my end if that's fine by you.
Yes. Please go ahead. Confirm that you can share so that. Go ahead, please.
Okay, Alan, please confirm you can see my screen.
Yes, very bright and bold. Please proceed.
Thank you. Okay. So I'm going to be speaking on cybersecurity basics, right? Alan, do you want to take the questions while I supply the answers?
No, you can just walk through your slides.
Okay,
and
then.
then I'll not necessarily.
Okay, so the first thing I would like to say, good afternoon, everyone. Thank you for having me here. I'm not very good with introductions. I don't like to pretend about that. I would like to get straight to the business of the day. The first thing I would like to say is that I always wonder, what is the business of privacy and cybersecurity? The nexus between privacy and cybersecurity is the fact that all of these rights that have been analyzed by the first two speakers are very important to the data subject, but they are also much more important to the data controller. And why is that so? Data is very key for the purpose of business. I don't have your phone number. How do I reach you? If I don't have your email, how do I send your legal documents to you? If I don't have your address, how do I bill the item you bought from my shop to you? So data is important for the purpose of business, but you cannot just take data because you need it for business at the expense of the data subjects. And that is where cybersecurity comes in. We often say that the day we have no need for privacy, on that day we have no need for cybersecurity. The cybersecurity is there because there is a need to protect privacy. And so while the data controller has a need to take the data, the data controller also has the responsibility, the legal mandate to protect that data he's taking from you. So he cannot say, after all, you gave it to me, you consented, or it's for lawful basis, justifies the lawful basis, and on the basis of that walks away. No, the law in section 39 of the Nigerian Data Protection Act makes it mandatory for the data controller or his processor to safeguard the data he has collected using technical and organizational measures. The use of the keyword technical and organizational is where cybersecurity needs to be. So the technical and organizational measures are cybersecurity principles. And so what's the point? The point is to ensure that that data you are collecting does not suffer any loss. I cannot give you my data and tomorrow you say, oh, I don't have it, or I don't remember where it is. I'm sure some of us have gone to hospitals and they don't have our hospital records anymore. It is the duty of the controller who has collected that data to ensure it is not lost, to ensure it is not altered. Imagine that when you reported in the hospital, you were asked, do you react to chloroquine? And you say yes. And then the nurse or the doctor now writes, not allergic to chloroquine instead of allergic to chloroquine. That is an alteration. So that alteration can have far-reaching implications. And then your data, for instance, imagine someone who went to the hospital and then has just discovered he has HIV. He doesn't even want his spouse or whoever he deals with to know about it. And then suddenly that information is on the streets. That data must be secured from unauthorized disclosure. When we talk of unauthorized disclosure, even members of that organization should not know except they need to know. That is when we talk about the principle of least privilege. Should only be given information that they need to do their job. And so if they have no need to access that data, they shouldn't. There must be access control. And so the law requires that the principle of confidentiality, integrity, and availability must be the primary focus of the data controller. What does confidentiality mean? I'm sure you and I already know. Nobody who doesn't need to see it should be available as at when needed. Now, the guide, which came out March 20th, 2025, goes further to emphasize on the need for the data controller to focus on a risk-based approach in handling this data. What does that mean? That when handling personal data, you should constantly ask yourself, what are the risks that the data subject may suffer as a result of my handling this data? And that aligns with the principle of processing personal data, which has to do with transparency and all of that. So you don't want to just do what you want to do because of your benefit as the controller, but you want to keep the data subject in mind to ensure that they do not suffer a risk as a result of the data they have given you. It is not a business as usual thing. It is not a suggestion. It is a mandate. And so when there are failures on the part of the controller or the processor, there are consequences. And you know, this failure we are talking about is usually very obvious at the point of when that organization has suffered a breach. I wouldn't want to go further into that aspect of the discussion. So what are the things the controller needs to put in place to secure this data? Access control, I already mentioned this. I'm sure you've seen on some doors in some organizations, out of bounds. You've also seen that before you access even your banking app that is your own, they will tell you put a password. They'll tell you we need to verify your face, put your thumbprint and all of that. Why are all of those things being done? To ensure that it is you who owns the account that is trying to access it. Access control. You can't control assets by mere words. You have to use technical measures as well to enforce them. So if, for instance, if we press the power button of a system that has the health data of patients in a hospital, and it comes on and lets you operate on that system, automatically there is no access control. But if you put it on and it says insert your password, it then means that if you are not having the right to use that system, automatically you cannot. Let's use the example of a mail. Access control has to do with layers by layers. What do you need to do your work? What you may have your account, I may have my account, we may be using the same system. What your account can access, for instance, in the hospital, they have the electronic health record system. It determines who can access what. If you are just the secretary of that hospital, you don't need the test result of patients. If you are the medical doctor, you need the test result, you need their history, that access will be given to you. If you are there as the lab attendant, you don't need to know the drugs being issued to a patient. You need to know, okay, what is the result? So these are the information. This is what we mean when we talk about access control. Multi-factor authentication. If I know your password, I can access your device or your account. But when multi-factor authentication comes in, is don't authenticate using one method. If the person has imputed a password, you want to probably use some form of biometric or a dual confirmation. Put your face, let's be sure it is you. Put your thumb, put your iris. Let us be sure that not just having the password is all it takes. Or sometimes we now have the OTP options too. So there are multiple ways to ensure that we are sure that the person who is trying to access that data is the one who has the right to do so. And then there is audit logging. This is very important. We often say in cybersecurity that we have three types of organizations: those that have been hacked, those that are about to be hacked, and those that have been hacked that do not know. Some organizations are not checking their logs. They are not checking their networks to see whether there are intrusions on their network. And so people are in their network, siphoning data without them knowing, because they are not auditing their logs. What does the log do? The log is like the digital footprint that you cannot deny its existence. For instance, your system has what we call the event manager, which has a record of every single thing that happens on that system. So if, for instance, you go, let's say you browse a network, you browse a website, and then you quickly delete the history from the cache, and then you assume that, oh, nobody knows I went to that website. If, for instance, the organization says, do not visit some certain website, maybe pornographic website or untrusted website, and then you do so, when you delete the history, you then assume, oh, nobody is going to know I was there. The logs must record it that you were there. They are digital. They are not things you can tamper with. They are not accessible. And so when those logs are being checked, it gives the data controller information as to what is happening, whether where he has stored his details, the data he has collected, are actually being assessed only by those who should assess it. When is it being assessed? Who is assessing it? Why are they assessing it? And so this also flows from your policy around your access control. So we have the technical, the administrative ways of actually handling all of these things. And then encryption and pseudonymization is even provided for in the law. Why do you need to encrypt? Because data will always transit on the digital network. So as it's moving, you want to use what we call the hypertext method, where the details, the way you want to put in your password, and all you see is the star. It's not showing you the alphabet or the figures or symbols the person is typing in. That's a type of encryption. But much more, it is putting the data in a unique code that even when that network is hacked, the hacker does not view the data, but views only those plenty codes you often see. I'm sure we've seen some of those things on some screens. Then what is pseudonymization? You have to de-identify that data. For instance, I walk into a place and then that organization has de-identified my data. Even when you see my date of birth and it is complete on let's say an Excel spreadsheet, because you cannot link that full date of birth to my name, I cannot now be worried whether that data has any issues. I don't know if we understand the point I'm making. You have to put it in a way that even if that data slips out, because there is no link between the name, the date of birth, the house address. So when you de-identify some of those columns, for instance, on an Excel sheet, the details being seen, it's no longer useful to the person who has seen it. For instance, you come across a WAEC result. You see A, B, oh no, I actually use a beautiful example. You see F. The next thing you want to know is who owns this result. But if the name of the owner of that result has been removed, automatically that information you now have is irrelevant. So organizations must take the pains to do this so that even when there's data leakage, it will not be to the detriment of the data subject. Data minimization is a principle that is very important because the more data you collect, the more responsibility to secure them falls on you. And data security is not cheap. You can imagine how often you have to back up your personal system or even your WhatsApp, and how many times you get notifications from Gmail, oh, your Gmail is full, because you are backing up your WhatsApp. You are just an individual. So how much more organizations? And so when the principle of minimization is used, it helps to reduce the workload on the data controller. And then risk assessment. Risk assessment cannot be overemphasized because the more you likely problems that you will face, the more you are able to put checks and balances in place to avert them. Incident response. This is very key because, like I said, 3 categories of organizations: hacked, about to be hacked but doesn't know. So if you do not have already planned ways of addressing the issues when they arise, you will find out that in the heat of that crisis, you may be confused as to even what to do. And so incident response is a proactive measure that is put in place by organizations to say, if something goes wrong, what do we do? Some organizations call it playbook. You already know those who will act, what they will do, how they will do it is already outlined. It is rehearsed over and over. It is reviewed from time to time. Best practices, best tools, best strategies are all in place. Why is it important to respond promptly? Because the earlier you respond, the better it is that you will mitigate the risk. I'll cite an example. Let's say you walk into your office and then you observe that your network activities are too high. And then you check and you discover there's what we call data exfiltration, meaning data is being stolen from your network. You quickly disconnect that source. what happens? It then means if, let's say, you had 3 million data that the hacker is trying to exfiltrate, and then you disconnect quickly, it means that maybe he has taken just 10 or 15 before you discovered it. You now see that you were able to save well over 2,990,000. So, but if you don't have a plan in place to respond quickly, it then means when you see it, you say, hey, what do you do? What do you do? You keep running about. Everybody is confused. But when there is a plan in place and everybody understands their role and how they go about it, it helps to mitigate the effect and impact of data breaches. Third-party due diligence is very important because sometimes your problem comes from outsiders. It could even be a man of straw invited to your premises to do some job for you. I don't know. I like to give this story. Grass cutters are invited to a bank's premises to do some clearing. And then one of the very zealous grass cutter decides that, oh, he just discovered a wire buried in the soil. He takes the pain to uproot it and says, Oga, I don't know, I saw this very clean wire. I don't know, it looks good. I don't know if he'll be looking for it. He doesn't realize he has just disconnected that bank from their network. He thought he was helping them. And so if you don't have plans on how to manage third parties, be it the uneducated, uninformed, men of straw, I don't know how to say it, unprofessional people who come to work within your premises, or the professionals. For instance, you are a data controller and you are working with a processor who have to give access to the data you have collected. For instance, hospitals. They collect the data of the patients and they have to hand it over to the vendors of the electronic health record system. So such people are capable of causing you untoward trouble because the law says that when it comes to data breaches and the relationship between the data controller and the data processor, it is a vicarious liability. So the need to manage third parties is very important. And then vulnerability testing. From time to time, you want to check if the doors are locked. When we say doors, not just the physical doors, but your network doors and every other place where you store data that has been collected. And when Microsoft shouts, oh, we have updated our Windows, or another app you are using says we have updated, please, update. That's what we call patch management. And you say, I don't know, the new interface may give problem. I remember that time GTB said we should update. That may be the source where everything can go wrong. So patch management, making sure that you are using the latest version of your security tools is very key. Physical security is very important because no matter how much you do in the cyberspace, if I have access to that device, your phone, your laptop, or your server room, physically, all those other fashion comes to naught. So physical security is very important. I'm sure some of us heard of the incident or in one of the banks where they said someone used the restroom and then climbed into their roof and was trying to tamper with their systems. So you see how far-reaching physical security or physical access can make nonsense of every other thing that has been put in place. Why is employee training and awareness important? It is because when it comes to insider threats, there is no limit to how far they can go because your insiders have that password you are trying to secure. They have access to everything you are trying to secure. And so when they become a problem from within, either out of ignorance or because someone is going to pay them to achieve it, you are going to have serious problems. Now, we have critical national infrastructures. Why are they critical? I'm sure I've been getting the messages, tampering with telecoms infrastructure is a crime. Desist from it, report any. I don't know if anyone else has been getting that text message. Why is NCC taking the pain to spend so much money to send out that message? Because critical national infrastructure is relevant to every one of us. I'm sure your law firm probably has a website. My law firm has a website. Every other person's law firm has a website. If that website is hacked, it affects just one organization. But when it comes to critical national infrastructure, it affects the entire nation. Be it hack to the power or the energy supply, be it hack to the water supply. Unfortunately, I'm sure most of the regions no longer enjoy unified supply of water. But let's say the telecom, imagine someone tampering with, let's just say, Nitel, or back in the days, that was the only source of telecommunication. So those infrastructure that makes the entire ecosystem of our nation function well are relevant to us as a nation. They are considered critical national infrastructure, and the law says they should not be tampered with. However, the people who are responsible for them, the agencies, have extra responsibility to secure them, carrying out periodic risk assessments, appointing data protection officers, and then complying with all the rules and principles as outlined by the National Data Protection Commission. So the list, from mining to transport to food and agriculture to defense and security, education, all of these health fall under what the sectors that what they work with are considered critical national infrastructure. Now, what is data breach? I've been talking of hack. Data breach, like we said, looking to the initial responsibility to secure, is when that security is lost. So data breach is now the opposite. When there is destruction, when there is loss, when there's alteration, when there's unauthorized disclosure of access to personal data, whether it's being transmitted by email, on website.
Okay. Yeah, hello? Okay, I don't know. We lost her. Maybe she'll join. But I think it's time for the last speaker, Ibukulua Owa. I don't know if she's on the call so that she can just say hi to us. She's from our regulators, the Nigeria Data Protection
Alan,
Commission.
can you still hear me?
Yes. Oh, okay. Oh, yeah, yes. Please, just help us with, all these things are technical. Just help us with like a 1 minute rundown, the bullet points, summary of what you've said, so that we don't forget the ones that you said already. It's very technical. So just help us with a quick rundown, and you just wait for us together with other speakers so that Ibukolua can take her session, and we'll come back. I think we have some interesting questions already. Over to you now, please.
Okay, so whatever tampers with that security is where the issue is. That is a breach. And so it is important that necessary steps are taken when breach occurs. Secure everything, contain it, remedy it, report to NDPC, and all of that. Finally, the emphasis for what we have been saying is that while we agree that data controllers have a need for data to run their business, both for their own benefit and the benefit of the data subjects, there is the need for that data to be secured. And there are best practices on how to secure them. And once an organization puts in the right steps on securing that data, they may face challenges, quite all right, but that challenge can be mitigated to the barest minimum. Thank you. Alan? Quiet. Alan, did you hear me? Can anyone else hear me?
Yes, we can hear you. I think Alan's network is not strong. Well, we heard you. Thank you very much. Since Alan is not here, I will proceed to invite our regulator, the Nigerian Data Protection Commission, represented by the Assistant Media Regulatory Unit, Ibukun Owa, for her presentation. Ibukun, please, can you confirm you can hear?
Hello, hi everyone. Good afternoon. Buko Olua from the Nigeria Data Protection here. Please confirm if I'm audible. I'm really sorry for joining late. I just finished from a panel discussion. That's why I'm even staying outside and I can't turn on my video. I feel like the noise affects the webinar. I'm really a bit sad that I wasn't able to hear the conversation because one thing I like to do is try to respond to comments from other speakers and the audience when I'm giving my comments on data protection and the regulatory aspect. So whatever I was saying, I probably limited to just what I prepared for, but not knowing what has been said before. I don't have a presentation because I was giving questions. So I thought it was more of a panel discussion. So I'm very happy for you to just answer the questions for the audience benefit, and then I will just give my answers. If that works for you.
Yes, the moderator is not here to take the questions. Yes, and I'm sure he's coming back to ask some questions because we have so many questions that we would like to know from the Nigerian Data Protection Commission. But I think he will soon join us. Unfortunately, okay, let's give him a minute. If not, then I will ask my own questions. Thank you. Yes. Thank you. Thank you. Okay. Hi, can you hear us? Okay. Yes. Yes.
Hello?
Okay. Yeah. The
Yes.
is yes. So following the case, I think there's a case law. The case law between Ikegai and NITDA, where the Federal High Court called data protection authorities review and update its white list of countries deemed to have adequate data protection laws. What are the factors that the NDPC will consider in conducting this review? That's the first question. I want you to take it together with this other question. What is the enforcement mechanisms and platforms for cross-border penalties, such as the $2 million fine on Meta, that is formerly Facebook? And may also ask you, what are the enforcement challenges that the Commission encounters in the performance of its statutory duties, and how do they navigate through such challenges?
Wow, so everything together. Okay.
Yes,
all
yes,
right.
please take all of them together. Yes. Starting with the first case.
Okay, all right, noted. Thank you. So before I answer the first question, just to note that decision was against the not the NDPC. So let's just note that it's not the NDPC. So the orders are not directed at the NDPC. But nonetheless, the question that you have asked is very, very important and significant. So how do we determine adequacy? Now, if you look at Part 8 of the Nigeria Data Protection Act from sections 41 to 43, that deals with cross-border data transfer. Section 41 states that you are not allowed to transfer data out of Nigeria without getting the adequate approval from the Commission. And the reason for this is that we need to be able to ensure that wherever you're putting data to, there is a level of adequacy to ensure that data is well protected. So we have now listed certain instruments that can be used for that. The first one is an adequacy decision, which is a decision that is issued by the Commission. So, for example, if a big data tech company wants to get approval from the Commission regarding the transfer of data from Nigeria to other parts of the world, and just to know that securing data in servers outside Nigeria also qualifies as transfer in this instance. So most of these big tech companies actually are involved in cross-border data transfer. But for you to get the approval of the Commission, you need an adequacy decision, which is a decision where you would look at all your processes and the instruments, the agreements you're using for this cross-border transfer. Then we'll now check to see whether there are certain principles that would give us a question that data being transferred will be secure. The second way is through cross-border data transfer instruments. That's through standard contractual clauses. Currently, we don't have at the Commission, because what this generally means is that there is a standard contract that the Commission is supposed to issue for anybody, any company to be able to rely on. They would impute their own information, edit it, and then send it back to the Commission for review, and then we can approve it. But as of now, we don't have that standard contractual clause put out yet. So that is not currently functioning under the Commission, but it's in the Act. So it's something that we're going to come up with, review, and draft and come up with in the near future. The next one is binding corporate rules, and that's where you have data transfers between a group of companies. So for example, now you have Total Nigeria. They may need to transfer data of their employees working here to France, their headquarters, for certain employee benefits, certain employee welfare. That's already cross-border data transfer. But because they'll be transferring it from Total Nigeria to Total France, it's an inter-group transfer. And in that case, they rely on binding corporate rules. You have code of conduct that different sectors would release. You have certification mechanisms like the ISO. The IT people on the call would understand the ISO mechanism. We have the 27701 for privacy, and then we have 27701 for privacy, and then we have 2770 for privacy, and then we have 27001 for information management. These sort of mechanisms are things that we'll look at to see whether you have adequate information management systems. Now, when you come to the Commission with those certain instruments, we will now look at certain factors which we have outlined in section 42 to see whether or not the particular instruments you intend to rely on is actually adequate. So what are those factors? So if you look at section 42 of the Act, the first one is availability of enforceable data subject rights. So we'll check to see that wherever you're transferring this data to, do they have enforceable data subject rights? So not only should they have the rights, they should also have active court presence, where people can go to court, active redress mechanism, go to court to complain about their rights not being enforced, and for them to be able to seek justice and redress. And we'll look at whether or not the rule of law is practiced and enforced in that particular jurisdiction. The second one we'll look at is whether there's any appropriate instrument between us at the Commission and the other authority where data will be transferred to. That can be form of an agreement, an international convention, and international agreements as well. Next thing we'll look at is whether there's access of a public authority to personal data. This deals more with government authorities and access to personal data, but under certain safeguards. The next thing we'll look at is there an effective data protection law in that particular jurisdiction where data will be transferred to? For example, we have the NDP Act in Nigeria. If you're transferring it to somewhere in Europe, we'll be looking at the GDPR. So we'll look at whether or not there's an effective data protection law. The next thing we'll look at is whether they have an effective data protection authority that can enforce the law. Like we at the Commission, we are the Data Protection Authority for Nigeria. If we're transferring to any other African country, for example, we'll check to see, do they have their own data protection authority? And are they able to enforce the data protection law in place? We would also look at whether or not there are international commitments and conventions binding us and other countries. So for example, now we are parties to the Global Privacy Assembly. If a country or a company that is that is looking to transfer data from Nigeria to another company or country that's part of the Global Parliamentary Assembly. It's one of the things that we'll look at, because we believe that if you're part of that assembly, they must have gone through your standards, your laws, your policies to see that you actually have an effective data protection ecosystem and regime within your country that can effectively protect whatever data is transferred to your country. So those are the factors that we'll look at in determining adequacy. And we've now taken it a step further with the NDP Act guide that was issued in March 2025. If you look at Schedule 5, all these particular factors that I've listed, we have now provided explanations on them as to certain things we look at when we're considering effective data protection law, when we're considering whether there's an effective supervisory data protection authority. We put the factors that we look at in determining that. So that is generally the framework that the Commission adopts in determining whether or not a country is adequate for cross-border data transfer or a company is adequate for cross-border data transfer. So that's for the first question. So I'll move to the second question now, which is in relation to enforcement mechanisms regarding cross-border data transfers. I'll first start with saying that there are no specific or express laws that only apply to cross-border data transfer in the Act. The same penalties that apply to general data breach will apply to cross-border data transfers. But because there is likelihood of a higher risk regarding cross-border data transfer, and there is likelihood of more harm being done to data subjects at a larger scale, those are things that we may consider in deciding the amount of the fine that we would issue. So that's one. The second one is to just know that you refer to the Meta case, but just to know that that particular sum wasn't just based on cross-border data transfer. We also found them in violation of other data protection provisions in the Act. So it wasn't just cross-border data transfers. We found them guilty for not obtaining consent regarding direct marketing, and also just some questionable behaviors regarding using children's data without their consent and not providing a safe place for children online. So just to know that there were different things that were considered in totality of that particular fine and sum. So now I'll specifically answer the question, what are the enforcement mechanisms? It's generally what you can find under our enforcement provisions under the Act, which is from Section 46 to Section 56. If we find out that a company is guilty of violating our Act, we have compliance orders that we can issue. We have enforcement orders that we can issue. In relation to compliance orders, we can issue cease and desist orders, which can also lead to us directing the stopping of data processing platforms from actually conducting any certain activity. We can also issue remedial directives telling you to do certain things to put your systems and processes in place regarding data protection. We can also issue you a warning stating that you have violated the Act. However, if you do this again, this certain measures will be issued against you. Those are compliance orders. Then we now have enforcement orders that we can issue, and that's where the fines and the sanctions come in, and that's also where we can issue an order requiring companies to compensate a data subject where we found that the breach has led to some financial loss or harm to the particular loss, harm, or injury to the particular data subject. Regarding fines, we can fine companies 2% of their annual gross revenue in the preceding financial year, or 10 million naira, whichever sum is higher. In practice, from what I've seen, generally the 2% is usually higher, so we usually use the 2%. But one thing to note is that that's it's discretionary. So 2% is the maximum that we can fine a company. So there's situations where we fine companies for like 0.01% of their annual gross revenue in the preceding financial year. We have fined 0.1 before. So we have that discretionary power to be able to decide what percentage to use, but the maximum is 2% of their annual gross revenue in the preceding financial year. Now, when a company now decides not to actually comply with the orders that we've issued or the fines or sanctions that we have issued, what we generally would do is that under section, I think it's 52 of the Act, there's the right to Section 50 of the Act, sorry, there's the right to judicial review, which you can find in general regulatory act, where you can take your decisions to court for a review on our order. So we let that time pass, and if that time has passed and you haven't exercised that particular right, we would then trigger Section 49 of the Act, which allows us to fine you for not complying with the Act, or also to take it to court. But these are things that we don't have the power to do, but we work with a police and investigations unit. So under the enforcement unit of the commission, we have an investigation unit that consists of a police department. So we have police people that are seconded to the commission to work with us. So in this sort of instance, if we have to trigger Section 49, we would work with the police team and we'll file an action in court regarding the violation of a particular order, referring to Section 49, and then asking the courts to grant an order, issuing further fine on the company for violating our initial fine order, or sending that particular company or sending that particular official to the company to jail for conviction for not complying with our orders. We can also, in certain extreme cases, we can also ask for both of this to be done. So we can ask that further fine be issued for non-compliance, and also an order convicting the person to jail for a period of 1 year. The Act limits it to 1 year. You can't fine somebody for more than 1 year. So that's how we would enforce non-compliance with fines and penalties that we have issued. So that's the second question. Now, the third question is in relation to enforcement challenges that we are currently facing at the Commission. I would say the biggest one is awareness. So a lot of people, if you consider the fact that Nigeria, we have about 230 million people, we have about 36 states, including the FCT, and the Commission is quite new. So we have a very lean team to compare that to how much people are in Nigeria. We have a lot to do regarding awareness, and we have done a lot, because as at now we have done over 10,000 awareness programs, but there's still a lot to do. So you have people in rural areas that don't even know about our act, and companies are actually taking advantage of them. If they don't know about our act, they don't know their rights. If they don't know about their rights, they cannot complain. So their rights don't end up getting enforced. Then you have companies that know about the commission, but just assume that it's just another government agency. What can they do? So most times it's until we issue an order against them before they take us seriously. So awareness is a very, very huge challenge for the commission. Another one that we have noticed is the cost of compliance. So you have companies that are saying things like, we don't have enough money to be able to hire the people that can be able to ensure that we have our processes in place. We can't hire a data protection officer. Most of the ones that we can find are expensive, and we don't even have enough people to be able to, enough pool of DPOs to be able to pick from. So what the commission is doing in relation to this is we have established a national certification program where we train data protection officers for a very major sum compared to how much you get the certificate abroad. And what we're trying to do with this is to close the skills gap in Nigeria. We just conducted a survey about 2 or 3 years ago, and we found out that we have over 500,000 companies in Nigeria. But at that time, we had only 5,000 DPOs, and our law under Section 13 says that every single company must have a data protection officer. So how we're trying to figure out how do we close this skills gap. So that's how we came up with this program. We've done the first batch of it, and we certified over 400 DPOs. The next one probably run next sometime, I think towards the last quarter of the year. If you go to IIM's website, that's the Information and Resource Management, you would see more information on this, because they are the ones that are working with the license certificate. So a lot of capacity building initiatives that we're trying to do, and that's one of them. The other challenge we find is people complain about regulatory complexity. Some people say that the laws may be a bit too complex for them to understand. People don't understand it because, like I said before, data protection is quite nascent in Nigeria. So we're currently working on sectoral guidelines to be able to explain what data protection compliance means in very, very key sectors in Nigeria. For example, the health sector that deals with sensitive personal data, the financial sector where we get so many people that on identity theft, the telecommunications sector as well, and then just big tech companies. We're coming up with sectoral guidelines. We are also coming up with webinars to issue out clarifications and advices where you can speak to our officers one-on-one to be able to break down our laws and explain it to you. So that's for regulatory complexity. Another issue that we find out a lot, that another challenge that we also encounter at the commission regarding compliance is people having that fear of if they have to comply with us, it may actually disrupt their operational systems. For example, conducting audits. And what we always advise is that they speak to DPCOs. So DPCOs are data protection compliance organizations, and they carry out compliance services for the commission. So we send people to them to be able to, thank you, to be able to speak to them as to how to comply and what is required. Then another one is people not understanding, there's insufficient understanding of emerging cyber threats and data protection. If people don't really understand what the issue is and what even the law says, it's very, very difficult for them to comply with that as well. Then we have neglect of compliance, which I've already spoken about. People knowing about the law, knowing about the act, even knowing about the standards, but actually not taking us seriously. But I would say that one thing that has helped is the issuance of fines to companies. People announcing that, oh, okay, if you don't comply, there are actually penalties for this. So I remember when the multi-choice fine came up, the multi-choice written fine of over 700 million. I know how many calls me and myself and my colleagues got just in relation to, oh, what are we supposed to do regarding data protection? What are the compliance metrics? We want to comply. And that really helped to be able to drive home what we've actually been advocating for the past 2 years. Then finally, we have managing vendor and third-party compliance. We realize that a lot of companies don't even understand that under Section 29, their vendors and facilitators are actually supposed to be compliant with our act. So when we call them in for investigations, we see them, we ask them questions, and they don't even have any documents to prove that their third parties are actually compliant. But these are things that we're also trying to solve as well by bringing up compliance templates that companies and their vendors can use, and also educating companies on the use of agreements to enforce compliance, conducting vendor due diligence to be able to see what companies are actually compliant with the act, and also just continuous monitoring. So that's an overview of the regulatory challenges. Thank you very much. I'm happy to answer any further questions that the audience may have. Thank you.
Thank you very much, Ibukun. I think I will formally hand over to Alan, the moderator, to continue. Alan, can you hear us? Hello? Okay. Thank you very much for that insightful section. We'll go to the general questions then, and because we still have, although we have less time now, we don't have so much time. So we'll just go to the general questions on the Q&A, and any of the facilitators here can take that question. What statutory provision govern data portability for adduction of evidence? I don't know, adduction of evidence, or how or which mediums are used. He said, what statutory provisions govern data portability for addition of evidence, how and which medium are used? I don't know whether any of the speakers is willing to take on that question. And let me also ask the second question I can see on the Q&A box. It talks about what specific protections are there for intellectual property. So I don't know whether anyone is also willing to take that question.
I think, hello?
Okay, yes.
I think I can deal with
this. Debbie,
yeah.
You want to take the question?
I can deal with the second question. I'm not very familiar with the legislation.
Okay,
in
please
Nigeria,
go on.
So I will deal with the second question. Intellectual
I'm happy to
property.
do question one when he's done.
Okay, cool. Thank you so much. The intellectual property is generally considered as commercial information because it does not talk about processing of personal data. The only personal data that we'll be talking about when we talk about intellectual property will be when you are talking about processing of the personal data of the author of the works that has been registered as intellectual property. So generally, intellectual property would not fall within the purview of data protection legislation because it is commercial information, and there's a very different regime for dealing with commercial information. However, when we are talking about the personal data of the author of the works, then personal data legislation will be engaged. Thank you.
All right, thank you very much. Okay, so I'm happy to answer the question on data portability. That's covered under the Nigeria Data Protection Act under Section 38. And then the NDP Act guide now provides further information and clarification on that. But the general law is that data service is entitled to the right of data portability, which means that you can ask a particular company to transfer your data from their own system to another company's system. You get this result within the health sector and the health industry, where you have people that may want to change their doctors or may want to see specific hospitals for specific problems, but their general health information is with a general hospital or another hospital. So they want you to move that data from the general hospital database to the specific hospital database. So they have that right under the law. And under the law, it's the right that it says that it should be transferred in a way that is machine readable and it's common and easy to understand. But it's important to know that there's also the caveat that says that this should only be enforced where it's technically possible to do it. So if a company can show that they don't have the systems in place to easily transfer this sort of data, then they would be protected. But generally, you have the right data portability. There are some exceptions under NDP Act guide in relation to national security and enforcement. They may limit that right, but generally, you have a right to tell companies to move the data from one company to another company. And the primary legislation that covers this is the Nigeria Data Protection Act and the NDP Act guide.
Thank you. Thank you very much for that insightful response. This question, I understand, goes to Onyinye, the cybersecurity person. He says, can we get examples of audit logging policy software? Can we get examples of audit logging policy softwares? I don't know if she wants to take a quick bite at that. Is she still on the call? Onyinye? Okay, maybe network issue. All right, so there's another question for Lesemi Wakoma that says, is there a limitation of action on data subject rights? So is there a limitation of action on data subject rights? If you are around, can you answer that? Or indeed any of the speakers can attempt that too.
No, there is a limitation of rights in data subject rights. People, I think it's important to know that data is personal information, so it belongs to you, and you have a right to decide when and how it should be used. However, there are certain rights that have limitations. So there are certain instances where you may not be able to exercise that right, but it's limited in relation to the context, not the period within which you can exercise that right. So, for example, now there is the right to deletion under the Act, but it's not an absolute right. You have that right, but if the data controller can show that there's public interest for them to still have your data, and there's some other circumstances under guide, they can also show that they have interest that that legitimacy is allowed under the law for them to be able to keep your data, then they would actually, you won't be able to exercise that right. So I'll give an example. There was a recent case regarding somebody that had been convicted and had served his jail term, and then he got released. But after 2 or 3 or 4 years, his information was still out in the public. And he complained to certain newspapers. I think he even wrote to Google as well for them to take that information down, but they did not listen. So he now filed an action under the right to deletion. And one of the things that the court had to consider was whether or not there was a public interest for that information to still be out there, because even if he has served a jail term, he was committed of a crime, and people should know this so that they can actually be safe. And the court has to consider the right of deletion in relation to the right of people being able to have important information that for the public. So those are things that the court consider in that particular instance. So there's no limitation regarding time period, but there's certain rights that in certain circumstances you may not be able to exercise them because there might be limitations. I can see that there is a question, because I feel like I'm a little useful because I'm trying. I think
Thank you very much. After that clarifies.
All right. I wanted to answer the question on audit I'm seeing on my system now, so that I can just deal with all the questions, because I'm in transit and I feel like maybe this
Okay. Thank you. Thank
Yes,
you, everyone.
please go ahead. I think go ahead and answer the question. That is it mandatory for a company processing data to file annual returns on data management compliance with the commission after an auditor audits compliance, or can an internal compliance officer be able to audit compliance and file the returns? I think that is the question. The reason for this question is due to the cost associated with engaging an external auditor.
So the short answer is no. Under the law, you are only supposed to file your audits through a DPCO, and there are certain reasons why that particular framework is in place, because so we have been able to vet them to see that they are able to conduct thorough data activities. So you can only submit through a DPCO. You can have your internal compliance, but that obligation to file your CAR on the 31st of March every year is still going to exist, and you still have to comply with it. Regarding costs, I know that there are different DPCOs that exist. Like you have DPCOs that charge you lesser than a much more or bigger DPCO. So I would say that this sort of issue can be resolved by maybe doing market research and trying to figure out DPCOs that generally we deal with smaller companies. And then you can have some sort of framework or agreement with them regarding the cost involved. But that obligation is mandatory, and you have to comply with it.
Right. Thank you. Thank you for your useful insight. Actually, we've come to the end of the webinar, and I can see questions coming in, and the questions are coming in quite late, honestly, because
can I take my own question, Alan? Can I take Okay, I'll just, we wouldn't want to begin to emphasize much on audit software, so it doesn't seem like we're advertising, but I'll just talk about Microsoft Purview. Microsoft Purview gives you an entire view of everything happening on your digital space, including tracking insider threats and different types of risk you can face. So Microsoft Purview is one that I can give firsthand that yes, I have used, and it's a great one. But there are several others. Based on what your organization can afford, you can opt for whichever one suits you. Thank you.
Okay, please can you spell that Microsoft what? Microsoft for
Purview. P-U-R-V-I-E-W.
Yes.
P-U-R-V-I-E-W. Microsoft Purview.
All right. Okay. Thank you very much. Thank you very much. Okay, so yes, let's say please, data subject rights.
So I got
Subject
disconnected at the point my question was asked. I don't know if I could still answer that.
Go ahead. Yes, yes. Go
Hello,
ahead.
can you hear me? Okay, on
Yes, I can hear you.
rights of subjects are bound by limitation period. So it depends on how these claims are brought. If a data subject brings a claim under data privacy, under the Constitution, under Section 37 of the Federal Republic of Nigeria, the Constitution, then the FREP rule applies. In that scenario, the statute of limitation does not catch up with that application. However, if the claim is brought under contract or breach of or tort or a tortious act, then the various statutory rights that are provided for under limitation periods would catch up with such proceedings or such actions or such breaches. Because as a data subject, you don't just know that your right is being breached and you go to sleep. Even if you file a formal complaint with the Nigerian Data Protection Commission as a data subject, if it's a tortious claim, if it's a tortious breach, you also need to know that there would be limitation right that will catch up with you as provided for by the statutes.
All right, thank you very much. Thank you very much, listening. All right, so I want to thank Mr. Gerby and our very resourceful speakers. And this is the point where I'll call on first of all, we've come to the end of today's presentation. So I'll call on the NBA Port Harcourt branch CLE chairman, our head of chambers, Mr. Henry Chibo, to give the closing remark if he's here, so that we can draw the curtains on this presentation. Thank you all for being an engaged audience and also for being very resourceful speakers. Thank you.
Okay.
I think for network.
Yes. Let me represent the chairman of the CLE Port Harcourt branch. I'm Isdo, the secretary of the CLE committee. And we are happy to have the very eminent and respected speakers on our invitation, starting with Mr. James Baby. When he started practicing data protection, some of us here have not been born. So it's good to have him on the call. We also thank Ibukun Owa, our regulator. It's a great honor to have him in our midst. It's good talking directly to those that are in charge of administering the Data Protection Act in Nigeria. Also, Lady Sami Wakoma, thank you very much for that insightful session. And thank you very much. If you go to the YouTube link, you will see the comments. People are really excited. They got so much out of the training. We are grateful, and I'm sure we are leaving here better persons. There are so many questions we are unable to take. But if it's possible, the IT will send some of these questions and even the slides. We'll try and send the slides to all the participants. So we thank the Port Harcourt branch for giving us the opportunity to host a link for our points on the chat box and also on the YouTube live chat. So if you've not filled the form, please go there and fill the form so that you'll be able to get your points. So I thank all the participants, the listeners, the speakers, the IT team, the members of the committee. We are grateful and we hope to see you again next week. Thank you very much. Thank you.
Thank you. Thank you. Thank you, everyone.
Thank you very much. Bye, everyone.
Thank you very much.